Yeah, thank you very much. Good morning, everyone, or rather good afternoon. It's a great pleasure for me to be here. It's my first visit to Roma, hopefully not the last. I can assure you I have a wonderful time, and yeah, I would like to express obviously my deep gratitude to the faculty for awarding this guest professorship to me, but also to my colleague and learned friend George Opino for having me here. So the topic I'm supposed to talk about is limits of rights. Which is a good coincidence because I have focused my own research in the last 2 decades or so on precisely this issue. How can we figure out what the limit of rights are, where exactly the limits lie, and this then of course leads quickly to the proportionality test. Simply for the reason that we don't have a good alternative to determine the limits except for proportionalities analysis. Proportionality simply is the best means we have to date. In future, maybe some genius may invent a different means, but to date, it is the best means. Mind you, this necessity to make a proportionality analysis in order to state where the limits of rights lie, this necessity to use proportionality is true for all rights, not just freedom of speech. So in that sense, much of what I'm going to say in the next minutes will be true for more or less all rights. Once you understand how proportionality works, you have a very powerful tool in your hand, for example, to advise your clients. If you work as a lawyer, a good tool to argue before a court, a good tool to criticize court judgments, and so on and so forth. The background of what I'm going to say is what we could say the structure of rights reasoning. So I would like to step back for a moment from the limits and from proportionality to give you a bit background picture. And this background picture will allow you to see where exactly we place proportionality analysis in the course of a longer argument, the longer argument being a rights reasoning. And by rights reasoning, I mean any argument that's supposed to answer the question, was fundamental right X violated or not? Was there a violation of the fundamental right X? And X could be any right, including the freedom of speech. So when we try to answer this question in law, and not in politics and not in moral philosophy or some other discipline, when we try to answer that question, was the right violated, we employ rights reasoning. And rights reasoning may have 2 very distinct structures. And this is here, this slide on 2 structures of rights reasoning. One-step structure and a 2-step structure. So the one-step structure of rights reasoning simply says, look, when we answer the question whether a right was violated, we simply answer that question, and that's it. Was there a violation? Yes or no? There's a binary coded answer to this, yes or no, 0 or 1. And we simply answer that questions, and then our rights reasoning is done. There's only this one step. This is not the view I'm going to defend. I follow the 2-step structure. And the 2-step structure works like this. It's a bit hidden in the second line here. we distinguish between a first step where we establish whether there was an infringement with the scope of a right. And only if we answer that question, the first question, was there an infringement with the scope? Only if you answer that in the affirmative. If you say, yes, in this case, there was indeed an infringement with fundamental right to free speech, then we move on to the second step. Given that there was an infringement, was it justified from the perspective of the Constitution or not? Was it justified or not? So let me briefly explain a bit more in detail these terms. So in the first step of the structure, we distinguish between a scope and an infringement. In this order, we first start with question, okay, is the scope open in our case? So for example, is this a freedom of speech case at all? Yeah, in the scope stage, which is the first substage, so to speak, from the first step here, yeah? First substage being scope and then infringement. Yeah, but now we are in the scope. There we delineate several fundamental rights. We say, is it a freedom of assembly scope, or rather freedom of speech scope, or something entirely else? Yeah. We name, we pinpoint, we identify the right that carries the main weight in our case. So that's the scope. Instead of scope, you could say area of protection. So you look into your case. Okay, what happened in the case? You say, well, he uttered a certain sentence. He said to my client the following phrase. And then you say, okay, is this behavior, saying this phrase, is it protected by the scope or not? Only if it is protected, so we say the scope is open for this right, you move on to the second sub-stage, infringement. Because that we have some protected behavior in the case is not yet sufficient to say the right may have been violated. The infringement is, instead of infringement, you could say interference. Here you ask, did the state infringe or interfere with this protected behavior? Did the state infringe with the scope of protection? For instance, by having a legal norm in place saying that certain utterances are forbidden. For instance, by stating hate speech is not allowed in our country, if there is such norm. Then we would say it could be a scope problem, yes, but if we are generous on the scope level, if we say everything is protected, then such a norm would infringe with my right to utter a certain insult, let's say, to a person. The idea here is that only if we have an infringement with a protected behavior, with the scope of a right, only then we move on to the justification stage. And also the justification stage, the second stage here, splits down into two substages. This actually is not visible on the slide though. So justification normally breaks down into first. Yes, sure.
Sorry.
No.
Just in order to avoid a possible confusion, because in the last few classes, we have talked about justification of the right to free speech, if you remember, right? Professor Klatt is talking about justification of the infringement.
Yes.
Okay. So, okay. The question is whether an interference with the right to free speech is justified.
Yes.
Okay.
Very important, very important. I'm not talking of a justification whether there is such a right or not. Yeah, thanks. That's very important. At this stage, guys, whenever you have any question whatsoever, please interrupt me immediately, raise your hands. I'm absolutely happy to answer questions as we go along. because what I'm going to say builds one step after the other. And if you get lost early on, then, yeah. So to make it worthwhile for you, please make sure if you have a comment or a question, pose it, yeah, as we go along. So that was important, the justification of an infringement. Maybe I should add at this stage, at this point, in order to explain even a bit deeper what I mean by justification in this context. You know immediately from the structure that we have two types of infringements with rights. So when the state, any state authority, infringes with a right by an action of a police officer, by a court judgment, yeah, all this could be infringements, interferences by a state authority, action of a police officer, court judgment, also a legal norm enacted by parliament can be an infringement with a right. We have two kinds of infringements or interferences, justified ones and unjustified ones, depending on how we answer the second step here, justification stage. And unjustified infringement will be an infringement that is tantamount to, synonymous to, a violation. Violation of a fundamental right is defined by being an unjustified infringement with a behavior that lies in the scope of a right. Sorry for some guys, I'm telling you basics here, but I understood it's a beginner's class, so I'm really doing basic stuff here. So two types of infringements, unjustified ones, violations, and justified ones. Yes, the state can interfere with our rights in a justified way, and then the right was not violated. It was infringed with, but justifiably so. So the right was not violated. This is a very important distinction we lawyers make in rights reasoning, because lay people often claim, yeah, but my right was violated. And I thought, oh, it may have been infringed with, but whether there is justification or not, we are just, it's our work, rights reasoners, to answer. There is a distinction between violation and infringement. Mind you, this is only so under the two-step structure. If you follow the one-step structure, all these questions are just, going back to the previous slide, two structures. Some say it's only one step. In the one-step structure, all infringements will immediately be violations. The differentiation between infringements and violations can only be done in this two-step structure. So I said that also the second step here, the justification stage, splits down into two substages. And this is so, first we ask, was there a limiting clause? And then second step will be proportionality test. So the first sub-test here is, was there a limiting clause? And this is something you guys may be familiar with. There are written and unwritten limiting clauses. There are fairly general limiting clauses, simply stating in a paragraph. So paragraph 1 of a certain article in the Constitution gives you a right, okay? Freedom of speech is granted, or whatever the formulation is. And then paragraph 2 says, this right can be limited by the state. This would be a general limitation clause. For some rights, we also have special, more concrete limitation clauses, which states particular grounds for the protection of which the right can be limited. So this is the case, for example, maybe you're familiar with the European Convention of Human Rights, Articles 8 to 10, follow exactly the same structure. Articles 8 to 10, paragraph 1 will give you a right, and paragraph 2 will limit it. But then having a catalog for certain reasons, so maybe limited for reasons of national security or so. These are just examples. And only if you have a limitation clause, then you can move on to the final step of the justification, and this will be proportionality test. So all this, what I've said so far, is just to provide the background in order for us to be able to see at which stage exactly in the rights reasoning process we employ proportionality, namely at the far end. Yeah? Only at the very, you have to, sometimes in an exam or so for a student, if they write a case solution or so, you write several pages on the scope question, then maybe it's debated whether there was an infringement. Yes, the state may claim, no, there was no infringement. Okay, many problems there, many pages to write. Only at the far end, you start the proportionality test, so to speak. Okay, let me check what else I should. Yeah, I think this suffices for the time being. What I'm going to do now is to introduce a case that concerns freedom of speech, just for us to be able to have a case at hand, so later we see better how the theory works in practice. I'm giving you still the theoretical structure and the methods and the important points, but still it's helpful to have a case. And I've chosen a case that plays a very prominent role also in Robert Alexi's writings. Sorry not to have been able to come up with a new one on my own, but it may have some advantage for some of you since you can read also upon it in Alexi's writing. So it's a case from Germany, from the German Constitutional Court. So let me briefly ask, who of you is familiar with this case? Oh, good. So it does not concern the movie, nor does it contain the ship. Titanic in Germany is a magazine, a satirical weekly magazine. Fairly widely published. So here is the background of this case is a true story that was reported in an ordinary newspaper. And the true story is this, that there was a reserve officer of the German army, a soldier, but in reserve, not an active profession. And he wanted to participate in military exercises. So the soldiers in Germany, as in other countries, from time to time, they get called, come together, and let's do some exercise, just to be sure, just to be safe, to be prepared. Okay. Yeah. The problem was that this specific reserve officer was sitting in a wheelchair. He was paraplegic. Yeah, he was sitting in a wheelchair. Still, he wanted to participate in an exercise. And apparently, under German army law, reserve officers not only had a duty to come, if called upon, to the exercise, but it was their right. But of course, German army never called him because they knew he was sitting in a wheelchair. It doesn't really make sense. So, according to them at least. So in the end, this reserve officer sued German army to enforce his right to get called for a military exercise. And he succeeded because it was a matter of German soldiers' law. So this is only a background. reported in some newspapers, Titanic found this at the satirical magazine. And they said, look, this is the perfect thing for us to make a bit fun of him. Yeah? That was their project. So they published pictures of someone sitting in a wheelchair. They described him in a cover story like a quote unquote born murderer. And they described him quote unquote cripple. Huh? This again, our reserve officer was not very pleased about because it was widely published in a printed magazine. He sued the magazine for damages before the civil courts law, civil law courts. And the officer argued that these descriptions, born murderer, cripple, violated his general personality rights. It's a fundamental right to have a good reputation, to have your honor protected. It's a fundamental right in Germany. The civil court ruled against the magazine. They said, yes, indeed, the officer is right. They violated his personality right under the German constitution. Hence, we, court, order the magazine to pay damages to him. 12,000 Deutschmarks back then. This was not to the pleasure of the magazine, of course, the Titanic. So they raised a constitutional complaint against this civil court judgment, ordering them to pay damages, and say, look, the order to pay damage to the officer violate our, Titanic's, freedom of speech. Now, we can say whatever we want. And if we want to say cripple, if we want to say born murderer, we do it. We have a protection. So this was why it ended up to be, although it started in the civil courts, a claim for damages, in the end, it ended up a freedom of speech case, okay? So far for an introduction into the case. The case is more or less clear. Good. So moving back to proportionality. I'm going to say a few words about proportionality, and then we go into the middle of what proportionality means, how we can split it down into several steps and so on. But the general remark is this, that proportionality is a general test that any interference with the human right must justify. I should probably say I use as synonyms the labels fundamental right, constitutional right, human right. Yeah? I don't make distinctions here for our purposes. Any interference with any of such rights must satisfy the proportionality test. Otherwise, the right was violated. And it's a very powerful analytical framework we have. And it's also an issue, we will later see this, that leads us into very abstract questions, theoretical questions, questions of constitutional theory, of reasoning theory, but also right in the middle of the lowlands of everyday legal practice, so to speak, because it plays such a great role in cases. It is a set of different subtests, and let's have a look at these subtests. So legitimate aim, suitability, necessity. The last step will be balancing. Sometimes the last step comes under a different name, a different label, proportionality in the narrow sense. Yeah. So in this terminology, the whole of all four steps will be proportionality in the wider sense. Then only the last step, balancing, will be proportionality in the narrow sense. Doesn't matter which labels you use. It's just a different label. The idea is that you start always with the first step and only move on, so to speak, in the sequence of this strict order. You should not mess around with beginning with step 4 or 3 or so. No, simply follow strictly these steps. So maybe let's start with legitimate aim. Sometimes there is a, in fact, I myself, I think, have defended a view that there are 5 steps. 5, and this would be a new second step, the others moving down 1 step. Then the second will be legitimate means, means and aim. So not only the aim needs to be tested, I'm going to explain all this in a minute, but also the means the state employs should be legitimate, which is true, but this is more familiar. This is why I have this. So a few words as to the legitimate aim. When the state infringes with our rights, the state must follow a legitimate aim. That is the first question we pose in our case. Was the aim the state pursued legitimate or not? This is not a very fierce filter, because nearly every aim is legitimate. So any lawful aim can be legitimate. This step then has not so much as a filter function as a function to prepare our next analysis, the next step of proportionality. So it has more a heuristic function to state clearly at the beginning of your proportionality analysis what exactly it was that the state hoped to achieve when it interfered with your rights. It is normally sufficient that this legitimate aim is stated by the state in very general terms. For instance, national security, immigration policy, sustainability of the environment, just to give you a few examples. Think of COVID pandemic times, protection of the national health system. All these aims, judged per se, so to speak, are on their own basis legitimate. We wouldn't doubt it. So, because it is sufficient to state it in a very general language, and because in modern constitutions there are just so many aims which are taken alone legitimate, it is very rare for the state to fail at this stage. In fact, I only know of one example where already at this stage the proportionality test was over because the state did not manage. And that is a case, if I remember, from the United Kingdom. There was the Rent Act 1977. I was born already, but not yet in kindergarten. 1977, UK issued the Rent Act. Why? Because they wanted to achieve a differential treatment in the, when you rent an apartment or a house in the United Kingdom, they wanted that same-sex couples are not as protected as different-sex couples in the rent law. In other words, 1977 UK Parliament wanted to discriminate against same-sex couples when it comes to renting houses. Hence, they passed the statute. What was the aim of the statute? It was discriminating against same-sex couples. Was that legitimate? No. No matter how big the interference was, no matter any considerations of balancing, of suitability, no. It was per se. If that's your aim, illegitimate, yes. So end of the story. But frankly, that's the only. I cannot make up more examples, but those will be hypothetical examples.
Question on this, because I'm curious. I mean, how far or how deep can you push the inquiry into this first sub-step, the legitimate aim? I mean, would a court engaged in proportionality analysis be content with the explicit aims of the state, or would the court push into real aims behind the words, behind the black letter rules? So, I mean, what's your impression on this?
I would say that would be a question that could not be answered by the proportionality theory alone, but which would have to be answered by a separate question, which is the control intensity, which with a supervising court controls someone else's decision on that question. So obviously the question, was this aim legitimate, could be answered with a fairly loose control intensity by a court. Like in your example, there was certain reasons were stated, certain aims were given by the interfering authority. Fine. Yeah. Then if the court says, fine, they had an aim, it was legitimate. If the control intensity is like this, then it's a very loose control intensity, differential, exactly. But as is true with all the other questions of proportionality step, the three others, also this question could be answered with a more strict rigor. But normally, in my impression, the strict rigor is employed further down the stream and not for the first step. Normally, courts, comparative constitutional laws establishes this. Normally, with a legitimate aim, we are fairly content to have a very loose scrutiny. But it's a very good question because it gives me the opportunity to convey to you that in my theory, at least, not so in some accounts of critics of proportionality, the question of control intensity is separate from proportionality structure. It's a different issue. We may come back to it later. Does this answer your question for the time? Maybe one more sentence to your question, Giorgio. And there is a reason why courts normally tend to be very differential with this. Because if they want to get stricter and stricter and stricter in controlling the legitimate aim, they may end up with doing the balancing, the last step already here. And that's not supposed to happen. So anyway, legitimate aims, as I mentioned in the beginning, sometimes are more limited, like in freedom of speech, according to Article 10, paragraph 2 of the European Convention of Human Rights, Strasbourg system. Reasons of national security may limit freedom of speech, not just any reason. So we have also two categories here for legitimate aims. We call them absolute and relative aims. An absolute aim is a principle that let's say Parliament is bound, is obliged to pursue. Say the Constitution says that social security must be protected. Then Parliament is not free whether it wants to pursue or not social security. No, it is obliged to do that. This would be an absolute aim, absolute because the Constitution itself says that this aim must be pursued. And if it must be pursued, it will be legitimate anyway. It's a majora ad minus. But then there are a second type called relative aims. Because more often than not, Parliament in a democracy is free to invent their own aims. They can just make up aims from their political program. If you have the majority in Parliament, fine, go ahead, invent your aims according to your political goals, and those will be relative aims. We speak of an aims selecting or aims setting, it's even better, aims setting discretion of Parliament. It's a certain type of the margin of appreciation for those of you who are familiar with Strasbourg doctrine. Okay, so let's go to our case. With all this we know about legitimate aims, Titanic case, ordering damages. What was the aim of the state interference? Any suggestions? It's an open question. In our Titanic case, what exactly was the aim? In our Titanic case, what exactly was the aim the state pursued when infringing with Titanic's freedom of speech?
Imposing damages.
Imposing damages, exactly. Yeah. I mean, that's the first thing you need to understand, that in this case, the state interference lies with the civil court judgment saying you pay damages. That's the interference.
To somebody who says you are a cripple and a war
born murderer. Yeah. Yeah. Exactly. To protect the dignity, or let's say the personal reputation, personality rights, general right to personality, however it's labeled, but you're dead right, to protect the dignity, the personality of that reserve officer. Yeah? And not to be labeled as born murderer and cripple. Yeah. So this is the aim. Was it legitimate? So only this aim per se for the state, is it legitimate for the state to protect personality rights of the citizens?
I think you have to put this first balance with freedom of speech, which is more ideal like in this case, because if like integrity is more important than freedom of speech.
Good that you say that, because that is exactly something we would not consider here, but rather further down the stream. Yeah? Because, I mean, in the end, you are, of course, right, in the sense that we need to balance this consideration, protecting the rights, with other rights. Yeah? But the legitimate aim is simply, what was the aim? Protecting the personality rights. Was it legitimate? Yes, it is per se, this aim, to have it is legitimate. Questions of a balance with countervailing rights only come later on in the proportionality test. Why could we say, what justification could we give for saying, yes, this aim was legitimate? Why exactly is it legitimate for the state to protect personality rights? Why? Well, the Constitution not only has a right to freedom of speech, freedom of press, the Constitution also has a right to protection of personality rights or dignity. Yeah? This right, protection of, sorry, you wanted to say something?
No, just like as a human, as like a common thing, because I'm human. In French, we have like this case of dignity. Like the case that cannot like throw a small person to the nightclub. It's a famous case in French because there's a nightclub organized that.
Oh yeah, the dwarf throwing.
Yeah.
Yes.
And to throw them, like,
yes.
There was a huge case because like, the guy said, "I want to throw. It's my job. It's really my job."
Okay. Fair enough.
Yeah. Said, no, you can't. It's human dignity.
True.
Because of humanity as a group, that's concept.
Yes. And this case you're mentioning now, of course, then raises the main question whether you can have your own right protected against your own will. Yeah. And that's of course an interesting question, but it's not exactly the question I'm going to tackle here in our Titanic case, because for reasons of time, maybe later. Protection of dignity is a right in the Constitution, let's say personality, general personality, reputation, your personal honor. Yeah? Well, this is not only a negative right, but also, as all rights, also have a positive obligation. So we could argue that pursuing the aim of protecting the personal honor of that reserve officer was a legitimate aim of the state because the state was even obliged to protect his general reputation by means of a positive obligation stemming from the reserve officer's rights. I mean, if you are even obliged to do something, that you can do it. Yeah, you can because you must. It's a kind of Kantian argument here. Anyway, the important bit so far is that do not mix in considerations of balancing into this first step. And this, I acknowledge, to some of you may sound weird. Yeah, may sound strange. How could I say it's legitimate? Because it may have collided with freedom of speech and so on. Well, the answer is that's precisely one of the advantages of this detailed structure, that we focus on one problem for the time. It gets more analytically clear that way compared to this big one-step question: was the right violated, yes or no? Yeah? Being in Rome, we could even underline this maybe with Augustus. Emperor Augustus had a certain method to govern his Roman Empire, divide et impera. Separate, it's a command, separate things, guy, and you will govern. And this is how proportionality works. We concentrate on one thing at a time, we separate analytically the steps, and then we get more convincing, it will be a better argument. Next step, we should move on. Is suitability. I give you the definition. Suitability of what for what? Yeah? Suitability of a certain means the state employs for achieving the legitimate aim. So here comes the second thing, a means. Yeah? The means must be suitable to achieve the aim, the legitimate aim from our first step. And the definition is that the means is, definition, a means is suitable.
We have an interference.
Do we? Yeah, maybe, sorry, maybe we can simply drag and drop it somewhere. Maybe. No.
Is it the X here?
Take the second thing.
Huh?
The lower, that the two options, the lower one, I guess. Don't do it now.
No, I don't understand. Don't understand. Yeah, okay. Yeah, we don't want to do it now. And then, yeah, brilliant. Okay. A means is suitable if it furthers the aim. A means is suitable if it furthers the aim. Again, this is not a big filter. This is not a big hurdle for the state to pass. Because it does not mean that the state must achieve the aim with the means 100%. 100% is not required. Any progress in protecting personal honor will be sufficient, will make the aim suitable. It's a low barrier again. And it's not a question of law. It's a purely empirical question. With these damages paid to the reserve officer, would we say that his personal reputation is protected better than without 12,000? Yes, I think we can say that, because he gets some compensation for the damage, and also Titanic in the future may be a bit more careful which words they use. Yeah? So ordering someone to pay damages is a means that actually furthers the protection of honors of other people. So we would say, yeah, it is a suitable means. The third step is called necessity. Necessity is a bit more complex. I give you the definition and then I explain. A means is necessary only if there is no less restrictive but equally protective measure available to further the aim. I repeat, a means is necessary only if there is no less restrictive but equally effective means available to further the aim. I mean, it sounds weird, but it gives you very clearly. Shall I repeat again?
Yeah.
Okay, good. A means is necessary only if there is no less restrictive but equally effective means available to further the aim. No less restrictive but equally effective means available to further the aim. Did you get that down? Brilliant. So now let's look. The necessity test forces us to step a moment away from the means that we have in our case. Remind me, what was the means in the Titanic case the state employed to pursue the aim? The means was damaging or a court order to pay damages. Yeah? This was the means. We now look for alternative means, which will be purely hypothetical. We get creative as lawyers. Which alternative means, hypothetically, could the state also have pursued? Hypothetical means. Of course, the list is very long. Here is a few suggestions. The state could have said, sorry, guy, you don't get any damages. No damages would be an alternative means. It could have said, maybe no damages, so no 0 Deutschmarks, 0 euros, but Titanic, you have to print a counter statement in your next issue. Yeah? Maybe this was an alternative means. The court could have said that. It could have said, yes, he gets damages, but only 6,000. Or it could have said, the third hypothetical means we could make up, we could say 12,000 for these insults, far too less. He should have gotten, I don't know, 15,000 euros maybe, higher damages. So all these means I've just named are means which the state did not employ, because in our case it did employ paying damages 6,000 euros. But anyway, in order to find out whether this means was necessary, we make a list of hypothetical means and then we test these hypothetical means, each of them, in 2 respects. First question, was it less restrictive to the right? And second question, was it equally effective? So we evaluate the hypothetical consequences these alternative means would have had for the 2 rights in conflict. So, no damages, only you have to print a counter statement. Well, we would say, no damages, counter statement, yeah, don't worry, a little notice like this size on page 16, we would say it would be less infringement with the freedom of speech. But it would also not be equally affected. It would protect the honor less. So this hypothetical means does not hinder the necessity of the means actually employed. Second hypothetical means, damages of 100 euros, 1,000 euros. Yeah? we would again say, again, less intrusive with the freedom of speech, but also not so good a protection. Again, does not hinder the necessity of the means actually employed, damages 12,000. And the third alternative means paying higher damages, ordering them to pay higher damages. Oh yes, this would be even a better protection of personal rights of the reserve officer, but it would also be more intrusive to the freedom of speech. So again, it does not hinder the necessity. Yeah.
This is an abstract law evaluation. It doesn't look at the complete subject. Okay.
Depends a bit, but yeah, as a rule of thumb, yes. It depends a bit, but because sometimes we control the concrete court judgment at the moment. But the concrete court judgment will only be constitutional if behind it stands a statute in civil law ordering damages and so on. And that statute also must be constitutional. And it depends a bit. If we talk of the proportionality analysis of the court judgment, yes, it will concern this concrete case. You're dead right. But this will only be a necessary condition, not a sufficient condition for the whole thing to be constitutional. The statute behind it, civil law, must also be constitutional, and those proportionality analysis will be a bit more abstract because it concerns several. Yeah, I can only indicate a.
I'm thinking, especially in freedom of expression cases, you might have on the one hand an individual, and on the other side a large journal or a large TV station, for whom damages are not a big problem.
Oh yes,
but retraction may be a big problem.
Ah, thanks. Yes, absolutely right. And we would have come to that later when we discuss balancing. Yeah, yeah. Mm.
So here it's just.
Yeah. So maybe also for reasons of time, we move on to the last step, balancing. I tell you a bit about balancing.
Yes,
and
maybe yeah. The picture illustrates nicely the idea of necessity. So if you want to
this one, yes.
Explain why it's there.
Yeah. Well, there's the saying that how does proportionality or necessity test translate into let's say common people thinking, and there is this saying in English that you should not use a sledgehammer to crack a nut. This is, yeah, exactly. Don't use a sledgehammer to crack a nut. Only employ those means that allow you to open the nut, not excessive means. That's the idea of the necessity test. Yes.
The sledgehammer would open it nuts, but it's too much. You don't need it.
Yeah.
Okay.
Yeah. Exactly. Yeah. Thanks, Jojo. That's very important. Yeah, so here is some further reading, and particularly the first publication by Alexei will give you the Titanic analysis, yeah, and the other book gives you more on proportionality in general. But let me move on to the last step, because simply for reasons of convenience from my place, it's a different presentation, and I realize we should be very fast, but we will.
Take your time.
Balancing. Yeah, it's here. So balancing, remember, is the last step of proportionality. Yeah. Instead of balancing, I could say proportionality in the narrow sense. Fourth and last step of balancing. And now I go to the basics here. I have one slide. Yes, and we only need this slide. The law of balancing runs like this. The more serious an infringement with a principle is, the more important the realization of the competing principle must be. Let me explain this. In the Titanic case, we have two principles, two rights colliding. On the one hand, we have the freedom of expression, the free speech of the Titanic magazine. And on the other hand, we have the personality right of the officer. two rights, two principles compete with each other. From physics, there is this idea when you have I don't know the English expression for that. If you fill water into a structure made of glass like this, and you fill, and then you have a mechanism like this. So imagine those are the two: freedom of expression, personality right. If I reduce the protection of the freedom of speech, I increase the protection of personality right. If I reduce protection of personality rights, though, I increase the titanic rights of freedom of speech. It works like this. So balancing is not a binary coded thing. It is a matter of degree. We don't say in a certain country freedom of speech is not protected. No, we say they have a bit lesser protection, gradually lesser protection, or gradually better protection of a different country. Protection of rights is a matter of degree. And balancing, guys, is that we look at both rights at the same time and determine at which kind of protection levels for both rights we should say that is lawful and that is not lawful or so. This is what balancing does. And this law of balancing tells us that balancing consists of 3 steps. And this is the most important thing I'm going to tell you today. So maybe you take that away as a take-home message. All balancings have 3 steps because we answer 3 distinct questions. First question of balancing. How serious was the infringement with right A? How serious was the infringement with right A? Second question in balancing. How important is realizing right B? How important is realizing right B? Third question, which of the 2 rights prevail? Which of the 2 rights prevail? I will explain this. For answering the first 2 questions, we use 3 options because the infringement with the right can be either light, moderate, or serious. Light, moderate, or serious. This is the triadic scale here on the slide. Serious. Sorry, there's a typo. So the infringement with the freedom of speech right could be light, moderate, or serious. And now come your company size aspect. Of course, it depends on the case. If Titanic is a worldwide media company, and they have to pay 12,000 Deutschmarks, they would probably do it from their letter stamps money. Yeah, the accountant doesn't even see it. On the other hand, if it's a small company, as it was, you may say, well, goodness, 6,000 euros, this may ruin us. And the infringement with the freedom of speech, freedom of press, is, depending on the context, on the situation of the company, maybe light or serious. It depends on the context. Depends on the circumstances of the case, guys. All balancings always depends on the circumstances of the case before you. This is the reason why sometimes freedom of speech wins and sometimes the countervailing wins. It depends because the case is different. So light, serious, and moderate. And then you answer the same question for how important was it to protect the personality right? Was it very important, seriously important, only moderately important? Or would we say, no, in this case, personality rights are not really an issue, but yeah, okay, if it is an issue, then maybe a light importance we can. And the third question of balancing will be very easy to answer, because depending on which values you have assigned to the first two answers, light, serious, moderate, you get your answer. Yeah. If you have freedom of speech serious, protection of personality moderate, then serious wins. Yeah, because serious is stronger than moderate. And then you state that in your final balancing statement. If you say, no, the interference with freedom of speech was only of a very light nature, but the protection of the personality rights was really seriously important for him, then you have light versus serious, and then of course the reserve officers' rights win. So sorry, I do rush a bit through this case now, but this is basically the idea how balancing works along these three very important steps using the three-step scale. The German court, the Constitutional Court in Karlsruhe, actually in this case, when decided, it made a difference between those two labels, born murderer and cripple. They said born murderer was not in a satirical context, the soldier and so on, was not so very serious an infringement with the protection of personality, whereas calling a disabled person sitting in a wheelchair cripple was really beyond, so to speak, very serious. So they came up with a kind of balanced judgment, making a distinction between those two. Yeah. I think I should probably stop here. I'm happy to stay on for questions, but depending on time we have.